Welcome back. In the last lectures, we discussed how law enforcement can compel assistance after it has some sort of court order against a particular target. In this lecture, we're going to look at prospective assistance, that is, requiring a communication system to be ready for future surveillance orders. Until 1994, this area of law really did not exist. And so, law enforcement had two options. It could request voluntary assistance from communication services, which would often provide it. Or, as we discussed in the last lectures, it could compel assistance in conjunction with a particular surveillance order. Law enforcement agencies, and especially the FBI, were very frustrated by that status quo. At a high level, they had a few concerns. The telecom industry was shifting from analog to digital transmission of communications. A lot of old gear was getting outmoded, and a lot of new gear didn't have planned capacity for surveillance. Police were also dissatisfied with the timeliness of communications assistance. Even if a telecom was totally cooperating, enabling interception could be a slow engineering process. The shift away from analog transmission compounded the problem. Another concern was that companies differed in the information they made available to law enforcement. Investigators weren't always able to get everything they wanted. And last, there wasn't much standardization in communications surveillance gear. Businesses and government agencies were coming up with ad hoc technical approaches. It wasn't so possible for police or telecoms to just buy gear off the shelf that would work. So, in the early 1990s, the law enforcement community launched an intense lobbying campaign led by the FBI. In fact, the FBI director made so many visits to Congress that legislators profusely thanked him for his time. And the result was a legislative package initially dubbed the Digital Telephony Act, and before passage, renamed the Communications Assistance for Law Enforcement Act. Since that's a mouthful, it's usually just called CALEA. Now, CALEA was a grand bargain between law enforcement, telecoms, and privacy groups. So, don't expect much consistency in what the provisions require. In fact, a few parts of CALEA are unambiguously privacy safeguards, and I want to highlight two of them. One element of the legislative package raised the D-order standard. We've already seen how a D-order requires reasonable, articulable suspicion. It wasn't always that way, though. When ECPA was first enacted, a D-order only required relevance. It was CALEA that moved the bar to reasonable, articulable suspicion. Another pro-privacy provision, which we've also already seen, clarified that prospective phone tracking through the phone company requires more than a pen trap order. With that background, I'd like to take the rest of CALEA in three parts. First, we'll work through the mechanics of CALEA, what's required, and how it's enforced. Second, we'll take a quick look at the status of encryption under CALEA. Last, we'll explore which communication services are covered by CALEA. So, let's start with a rough overview of the mechanics. And the basic structure of CALEA is a three-step process. It begins with the private sector proposing a technical standard for facilitating surveillance. Then, if there's some objection, the Federal Communications Commission reviews that standard to make sure it lines up with statutory requirements. Finally, the standard gets enforced. Companies are required to adopt it. Now let me give a little more detail on each of these three steps, starting with private sector proposals. The first CALEA standard, of course, dealt with phone surveillance. It received the awkward title JSTD-025, and usually is just called the J standard. It specifies technical interfaces and protocols for connecting a phone company to a law enforcement agency. The initial design and rollout of the J standard was exceedingly slow, It took about a decade. These days, the J standard is pervasive. It's supported by just about every phone company in the United States. The J standard is certainly not the only CALEA standard. There are now about 25 of them, and you can pull the list from an FBI website. I should note that there is a fallback provision if the private sector fails to deliver a standard. The Federal Communications Commission can then write its own standard. That hasn't come up, though. Now let's turn to review by the FCC. If a telecom, or a law enforcement agency, or a civil society group is dissatisfied with a private sector standard, it can file a challenge with the FCC. And roughly, there are two sorts of challenges that might be filed. One type argues that the standard goes too far. It imposes requirements beyond those in CALEA's statutory provisions. The other sort of challenge is the opposite. It argues that the standard doesn't do enough. It doesn't satisfy CALEA's requirements. I've added asterisks after CALEA for a very important reason. When reviewing a private sector standard, the FCC necessarily has to interpret CALEA's statutory provisions. And when it does that interpretation, the FCC gets legal deference. It has some wiggle room to stretch out CALEA's provisions. Put differently, when CALEA requirements are challenged in court, the court doesn't ask how it would read CALEA. Instead, it asks whether the FCC's reading of CALEA is plausible. Using its interpretive power, the FCC has construed CALEA to cover some categories of information that may not be quite clear from the statutory text. For instance, which tower a cell phone has connected to. I think it's fair to say that around 2000, the FCC gave the law enforcement community almost all the capabilities that it requested, but not all of them. Okay, so there's the FCC's standard review process. Now on to the last step, enforcement. The government can, essentially, require a company to adopt the relevant CALEA standards. More precisely, the government can require capabilities under CALEA, and then a company has a safe harbor from that liability if it adopts the relevant standards. There are several ways in which the government can bring a CALEA enforcement action. The statute expressly allows for civil suits by the Department of Justice. Also, if there's a valid interception order that's been issued, CALEA allows spinning off an enforcement proceeding. In that context, CALEA functions much like the ECPA assistance orders that we've already seen. Finally, the FCC has asserted that it has authority to enforce its own CALEA rules. So, there are the three ways in which a company can be compelled to become CALEA compliant. I should note that CALEA includes several reimbursement provisions to compensate businesses for getting compliant. When CALEA was enacted, in fact, Congress allocated $500 million as a reimbursement fund. Some of the reimbursement was discretionary, and some of it was a precondition for enforcing CALEA where old phone equipment was involved. All right, so that's a rough roadmap through the mechanics of CALEA. Now let's turn to encryption. And there's a provision of CALEA that directly addresses the subject. It reads that a telecommunications carrier shall not be responsible for decrypting or ensuring the government's ability to decrypt any communication encrypted by a subscriber or customer unless the encryption was provided by the carrier and the carrier possesses the information necessary to decrypt the communication. Let me unpack that legalese. What it means is that under CALEA, a company cannot be required to build a backdoor. If a communication system has security protections that totally prevent the company from listening in, The company cannot be required to eliminate those protections. If you happen to have a technical background, let me give a more precise explanation. The provision means that end-to-end encryption is exempt from CALEA, but only so long as users manage their own keys. Centrally managed encryption, where service issues keys or keeps a backup of keys, is still covered under CALEA. Similarly, transport encryption, where communications are encrypted only between the service and the users, is still covered. Both of those designs are quite common. Okay, so that's the status of encryption under CALEA. Let's turn to the final subject, which is what's covered by CALEA. The statutory scheme draws a distinction between two kinds of communication services. One category consists of, quote, telecommunications carriers, unquote. The other category consists of, quote, information services, unquote. Telecommunications carriers are covered by CALEA. Information services, however, are not covered by CALEA. This was one of the fundamental compromises in the CALEA Grand Bargain. Under the statute's text, traditional phone services are unambiguously covered as telecommunications carriers, and email services and websites are unambiguously not covered as information services. So, those are the easy technologies to classify under CALEA. The distinctions, I would note, map very closely to how the FCC has generally regulated communication services. I also hope you see the structure of the legislative bargain here. The law enforcement community got the telephone system, which is what it cared most about, and privacy advocates were able to carve out more modern technologies. All right, those were the easy technologies. CALEA's text includes a provision that covers substantial replacements for the phone system as telecommunications carriers, but only to the extent they aren't information services. If that sounds like wishy-washy legalese, you're right on. The substantial replacement provision of CALEA is frustratingly vague. And in particular, in the early 2000s, there was substantial debate about whether two technologies were covered by CALEA. The first was voice over IP, or VoIP, that is, voice calls placed using the internet. And the second communications technology was broadband internet service. I think it's fair to say that the legislative history of CALEA reflects some intent to cover VoIP as a replacement for phones, and that the FCC's past views had hinted that VoIP would be covered. I also think it's fair to say that legislative and regulatory history really cut against including broadband internet service. The law enforcement community lobbied the FCC hard to cover these technologies, and the privacy community did the opposite. In 2004, the FCC announced how it planned to treat these newer technologies. It reasoned telecommunications carriers and information services aren't mutually exclusive. Where they overlap, a technology gets sliced and diced. The telecommunications carrier part of that technology is covered by CALEA, and the information services part of that technology isn't covered. That interpretation was surprising to many observers who thought the two categories were mutually exclusive. In fact, under the FCC's general authority, the parallel categories are mutually exclusive. So, the FCC decided that to the extent VoIP and broadband internet service were telecommunications carriers, they were covered by CALEA. Specifically, the agency's rules covered VoIP systems that were interconnected with traditional telephones. If there was any capacity to call an ordinary phone, all voice calls on a system were covered by CALEA. The agency's rules also covered broadband internet, reasoning that it had effectively replaced dial-up internet, which used the phone system. While services that run over the internet mostly weren't covered by CALEA, the FCC ruled that the underlying data flows passing through broadband internet service providers were covered by CALEA. As an aside, the FCC punted on decentralized service providers like mesh networks, though that really hasn't come up since. Okay, unsurprisingly, there was a court challenge. And in 2006, just a month after oral argument, a panel of the DC Circuit handed down its opinion. By a vote of 3-0, it upheld the FCC's rule classifying interconnected VoIP as a covered telecommunication carrier. The judges thought that voice over IP was pretty clearly a substantial replacement for the phone system, and it wasn't an information service. By a vote of 2-1, the panel also upheld the FCC's rule classifying broadband internet service as a covered telecommunications carrier. 2 judges thought CALEA was ambiguous, and while they might not have agreed with the FCC's rule, the agency's interpretation was entitled to deference. In a sharp dissent, the 3rd judge argued that broadband internet was unambiguously an information service, and therefore unambiguously not covered by CALEA. What we see in this case, he wrote, is an agency attempting to squeeze authority from a statute that does not give it. The FCC's interpretation completely nullifies the information services exception and manufactures broad new powers out of thin air. So, that's where we are today. Interconnected VoIP and broadband internet are covered by CALEA. That's what I wanted to say about CALEA's coverage, and that brings to a close the material on prospective assistance to law enforcement. Let me recap, just for clarity, the analysis that's required when applying CALEA to a new technology. First, you have to ask whether the technology is covered by CALEA. That involves the tricky categories we just worked through. For most instances of modern information technology, the answer will be no, because of the information service exception. Second, you have to ask whether the technology is within the encryption exception. That involves carefully thinking through how the encryption has been implemented and whether the service holds a copy of a user's keys. Most technologies don't fall within this exception. Those that do have been very deliberately designed for security. Last, if you've concluded that the technology is covered, and you've concluded the encryption exception doesn't apply, then you get to issues of the appropriate technical standard and how to enforce it. So, there's CALEA. In the next lecture, we're going to look at the law that applies when the government tries to compel a person to decrypt their data.